Well, welcome viewers, Dr. J.W. Ayoub, theologist, since 1994. Just in the momentum of the Women's Right Matters situation at the moment and the bill that's been offered to Parliament, Australia and the world's watching, and I think it's a time for clarity. Just given that I'm just an Australian citizen, I'm not claiming to be anything more than that, a Christian Australian citizen. In my observation of this, I wanted to come up with an immediate decision argument and where that would put the Albanese government, what position they're in, what sort of ways in which they'd be looking at this, because they're well aware of it. Could this be something that brings back an element of popularity for the Albanese government, given the devastation that's inflicting them at the moment after the 2026 budget and the Royal Commission into Anti-Semitism and other things that they've been confronted with? I offer you this, the immediate decision argument. The Albanese government may have reached the point where delay creates more political damage than decision. For years, the debate surrounding sex, gender identity, legal definitions, and anti-discrimination law has been treated as a specialised policy issue. Governments, institutions, corporations, and advocacy groups have repeatedly assured the public that the matter was settled. Yet the argument has not disappeared. It has widened, it's escalated, it's multiplied, it's actually become catastrophic. Court cases have widened it, women's sports have widened it, prison policies have widened it, school policies have widened it, medical debates have widened it. And the longer the issue remains unresolved, the more Australians begin asking the deeper question. What happens when government definitions appear to move away from what any and many citizens regard as observable reality? So the question matters because governments ultimately govern through public confidence. Citizens can tolerate disagreement. Citizens can tolerate complexity. Citizens can even tolerate unpopular decisions. But what we citizens are struggling with and finding it hard to tolerate is uncertainty surrounding the foundations upon which law itself operates. The category of biological sex sits within that foundation. A government cannot effectively administer female sporting competitions without sex. It cannot responsibly govern women's refuges without sex. It cannot safely manage female prisons without sex. It cannot properly regulate intimate care services without sex. It cannot produce coherent health policy without sex. And it cannot maintain confidence in sex-based legal protections if the underlying category itself becomes unstable. And this is where the strongest immediate option emerges. Not full appeal, not legislative demolition, not years of additional review, correction. A targeted legislative clarification restoring biological sex as the governing legal category wherever sex-based rights, protections, exemptions, privacy interests, safety considerations, sporting categories, correctional facilities, medical services and female-only spaces are concerned. Such a move would immediately change the political terrain. Opponents would attempt to frame the decision as possibly hostility, possibly a desperate outreach for vote recalibration, but supporters would frame it as common sense. But the government's framing is what matters most right now. The government could say, we are preserving dignity for every Australian. We are maintaining protection from unjust discrimination, but we are restoring legal clarity where clarity is necessary. And that distinction is politically significant, viewers and listeners, because the public generally recognises the difference between treating people respectfully and restructuring legal reality. The first is a matter of human dignity. The second is a matter of governance. And governance depends upon definitions that can survive practical application. And the strongest recovery path, therefore, does not require Albanese to revisit every reform enacted since 2013. It requires his government to demonstrate that government is still capable of distinguishing, listeners and viewers, distinguishing between compassion and confusion, between inclusion and incoherence, between administrative flexibility and legal instability. The political opportunity sits precisely there. Not in declaring war on previous legislation, not in attempting to erase an entire decade of legal development, but in restoring confidence that Australian law remains anchored to categories that citizens, institutions, courts, families and public services can consistently understand and apply. Because once the public begins believing that government is unwilling to name obvious realities, every other assurance becomes harder to trust. And once trust begins to erode, budgets, promises, announcements, and political narratives lose much of their persuasive power. And that's why the strongest immediate decision is not repeal. It is correction. Not because correction satisfies every side, but because it offers the most credible path to restoring legal clarity, public confidence, and institutional legitimacy at the same time. I'm Dr. J.W. Ayoub, theologist since 1994. Like and subscribe to help the channel, subscribe and comment to educate me, and share the video to help somebody else.